Thank you very much for the introduction, Sandy. It's my pleasure to introduce to you today a panel on a very topical issue, the intersection between criminal law and prosecution and migration, which has obviously been a very active issue on both sides of the Atlantic. Before I introduce our panel members, I want to give a little plug for our committee. So as Sandy mentioned, for those of you that don't know me, my name is Tyler Hodgson. I'm the co-chair of the International Committee and was actually appointed to that prestigious position by Bill Shepard, who's in the audience, around halfway to the back. We have our meeting tomorrow at 10:15 a.m. It's on the 9th floor, which is, room number 9, 3rd floor. I've been told just across from where you had lunch today. So it's an open meeting, and we would certainly welcome anyone that's interested to attend. So I'm going to introduce our speakers. Starting at my far left is Chris Rickard. Chris Rickard is Policy Counsel at the American Civil Liberties Union National Political Advocacy Department and does administrative and legislative advocacy on border and immigration issues. Prior to joining the ACLU, Chris spent 7 years at the U.S. Court of Appeals for the Ninth Circuit in San Francisco as a law clerk and staff attorney, and then worked for the Miami law firm, I hope I pronounced this right, of Kurzban, Wagner, Porcelli, and Pratt. And in full disclosure, a very long time ago, Chris and I went to high school together. But that's not why he's here today. Next to Chris is the Honorable Anthony Porcelli. Judge Porcelli was sworn in as a U.S. Magistrate Judge for the Middle District of Florida in August 2009. Prior to that, he worked at the U.S. Attorney's Office from 2000 to 2009 and tried over 30 federal criminal trials, including one, according to the Tampa Bay Times and Tribune, that involved the case of a British national convicted in a complicated scheme involving international drug trafficking and materials for a dirty bomb. Judge Porcelli teaches e-discovery at Stetson College of Law as an adjunct professor. Following his graduation from law school, Judge Porcelli served as a law clerk for the Honorable Harvey Schlesinger. Then to my immediate left is Judge Carlos Mendoza. And Judge Mendoza was appointed to the bench of the 7th Judicial Circuit in 2011. He served as an assistant city attorney for the city of St. Augustine. Prior to his initial appointment, he enlisted in the United States Marine Corps, and upon graduating from high school, participated in combat operations in Desert Storm and Desert Shield. On February the 6th of 2014, President Obama nominated Judge Mendoza to serve as a United States District Court Judge for the Middle District of Florida. On June 24, 2014, the U.S. Senate voted unanimously in favor of his final confirmation, and he received his judicial commission on June 27, 2014. Now, unfortunately, we were supposed to be joined by Marcus Rubenstahl today, who is a lawyer from Germany, to give us a perspective on the EU and this issue of migration in the criminal law. We have circulated Mr. Rubenstahl's material. None of us on the panel feel competent to speak to the EU's position on migration in the criminal law. So we do have his material for review, but we're going to today start instead with the U.S. view on this issue. I'm going to ask Chris Rickard to speak to it. Obviously, we've all been reading the news about the caravan proceeding north towards the U.S. border. So it's an issue that's very much in the news today as we speak. And I'll ask Chris to give a general introduction both to the U.S. perspective as well as his own personal perspective on the issue. I don't know if you want to use the...
Thank you. Is that good at the back? Absolutely. Thank you. I wanted to start by thanking Tyler, Sandy, Carol, and the Criminal Justice Section for inviting me to be on this distinguished panel. It's a great pleasure, and I really respect the work you do and the glimpses I've had in the last 2 days of a really wonderful group. I look forward to our discussion. I had been thinking that the breaking news that I would discuss was the caravan and the National Guard, but I'm sure unrelated to the panel, the Attorney General has just issued a memo that is very relevant, and it's dated today, in fact, I think between lunch and now, and it reacts, as the President did this week, to what DHS and DOJ are presenting as a great increase in the number of apprehensions at the southwest border. And Attorney General Sessions says, the recent increase in aliens illegally crossing our southwest border requires an updated approach. Past prosecution initiatives in certain districts, such as Operation Streamline, led to a decrease in illegal activities in those districts. We must continue to execute effective policies to meet new challenges. Accordingly, I direct each United States Attorney's Office along the southwest border, to the extent practicable and in consultation with DHS, to adopt immediately a zero-tolerance policy for all offenses referred for prosecution under Section 1325A. We'll be discussing that. That's the illegal entry part of 8 U.S. Code. This zero-tolerance policy shall supersede any existing policies. If adopting such a policy requires additional resources, each office shall identify and request such additional resources. So the word that stands out, I'm sure to you as well as to me, is zero tolerance. This is a code for going back to prosecution initiatives that date to 2005, where this Operation Streamline that we'll lay out a bit came to the southwest border in Del Rio, Texas. And zero tolerance refers to prosecuting as many people as you can without the distinctions that one usually feeds into prosecution decisions. And it's led to a lot of the issues that I'll discuss and that the ACLU has been involved in terms of the criminalization of migration in the U.S. But Attorney General Sessions was building on a memo that he issued about a year ago in April 2017 when he gave a speech in Nogales, essentially calling for a return to certain prosecution practices that he's laying out even more today. But the theme of my talk, which I think I'll break into 3, is continuity and change. This isn't as new as some of the other Trump immigration and prosecution initiatives may be. This is something that has dated back, as I said, to the Bush administration and led to extremely high levels of prosecutions in the Obama administration. That's not to say that things aren't different in kind as well as degree now, in that it's become nationalized, and there are different types of prosecutions, as you can gather from the memo, with this zero tolerance theme. So I'll start talking a bit about the Obama years, get into that Sessions memo, and then the third part, which I think would be very interesting to get the judges' perspectives on, as well as to discuss, is family separation, how this affects a family that is involved. We know there are a lot of mixed status families involved in these cases, but also families coming to the border. The ACLU has just been involved in a lawsuit where a young girl was separated from her mother. They were from the Congo. The mother was kept in detention, immigration detention in San Diego. The 8-year-old girl was taken to Chicago in an Office of Refugee Resettlement facility, and they were separated for 4 months without contact. This is also playing out in the criminal context. This 1325, the illegal entry charge, is being used to separate families at the border because, of course, families can't stay intact in the Bureau of Prisons or in Marshals facilities, and this is a means of deterrence. This is a means of saying, if you get to the border with your child, we can prosecute you and separate the child. And I know the judges have seen many of the cases where families are affected, and I think it'll be very interesting to think about that. The first part is more the continuity side. How are we in a context where CBP, which is Customs and Border Protection, the parent of Border Patrol, referring more people for prosecution than the FBI? How has DHS become so involved in the federal criminal system? How are Latinos in this decade making up more than half of the new federal prisoners sentenced to time? And how are the caseloads being affected? We spoke a little at lunch about the southwest border district judges. I mean, there have been judicial emergencies declared. The tragic death of Judge Roll in Arizona was apparently when he was going to talk to Representative Giffords about the judicial emergency in that district, which was directly related to these immigration prosecutions. And I think the caseloads have also had enormous effects on different parts of the government. Marshals facilities, the Bureau of Prisons, and also due process. There have been cases brought, some successful, some not, in terms of the streamlined procedures, and that's really the other half of this. There's the zero tolerance, and there's also the how you treat cases en masse. So you're getting 70, 80 people streamlined, which means from soup to nuts in the criminal process, these cases go from plea to sentencing in a lightning speed and at high volume. And what are the implications of that for due process? And most recently, an interesting example of that has been the shackling case, which is now at the Supreme Court, in fact, was just argued. The shackling case is coming out of the Ninth Circuit, and the question is whether defendants can be presented shackled in their proceedings. And a lot of this is because of mass shackling of defendants in the immigration context in these streamlined cases. They've been shuffling in Arizona courtrooms, for instance, in Tucson, Nogales, and it gives quite a perspective. Some people in the audience may have seen some of these mass pleas, but just having gone in McAllen and in Tucson, you never forget it. It's not the justice system you're taught about. It's not the time or the individual attention that one expects. And they're people who are wearing the clothes that they wore across the desert. And that creates another context, even if someone isn't shackled. So in 2009, these immigration cases and prosecutions and convictions overtook in the federal system the sum total of all the violent, weapons, and property offenses in the federal system. They are more than 50% of the federal criminal caseload. And the ACLU came to it from a couple of perspectives. We certainly were interested in the due process, but a lot of what we were looking at were where people were sentenced. Some of them were held in marshals facilities, time served, and then most often deported. But others were sent to private prisons, which are called criminal alien requirement facilities, often in Texas or the South. And we produced a report, which is in your materials, called Warehoused and Forgotten, looking at some of these things in the context of private prisons more generally, but also what's particular to the immigration context, the lack of programming, the differences in terms of being able, at least through BOP, to have different grievance procedures, to have FOIA requirements that apply. These were really horrible conditions, but also led to riots. In one of the car facilities in Mississippi, there was a riot. In another facility in Texas, Willacy, in a place called Raymondville in South Texas, ICE decided that the facility wasn't up to their standards. So they, in 2011, said, this contract is void. A month later, this was picked up as a criminal alien requirement facility by the Bureau of Prisons. And in 2015, tragically, there was another riot at this tent facility. It's really Kevlar tents, where the facility was more or less destroyed, having a big impact on, of course, the local community and the economy, but even more so putting people who were detained and the guards in terrible danger. So these facilities are a part of the federal criminal and detention side that may not get enough attention. And by the end of the Obama years, we know that DOJ was looking at least on the criminal side to phase out these private prisons. They might still be used for immigration civil detention. We disagreed with that, but there was a commitment that these private prisons were not the way forward. We know that's very different today. And the other thing that was very different and is topical because of the Sessions memo is that by the end of the Obama administration, even though the prosecutions were at record highs, 1325, which is the illegal entry, the first type of conviction, and 1326 is re-entry, having been deported. The 1325s were de-emphasized. There was a clear trend to reduce the use of this offense that the Attorney General today has called for a zero-tolerance approach. And I think that came about because of several things. There was attention within DHS, for instance, by the Inspector General to how exactly these prosecution decisions were being made. Border Patrol was referring individuals for prosecution based on something that sounds very Orwellian. It's the consequence delivery system. And every Border Patrol sector has a chart depending on characteristics such as prior entry, criminal convictions, of course. There were also, at some points, family ties, et cetera. And the chart would lead to a consequence. The idea was, you've heard this catch and release. The idea was that people were being let go without a consequence. And so everyone who was apprehended would get a consequence based on this chart, which recommended a punishment. And then the local Border Patrol sector, this wasn't national, this was all done locally, would apply that if they could, if there was capacity. And the consequence delivery system included boxes that said prosecute. And so people would be referred over if there was room in the system. Now, some of the prosecutors ended up being the same Border Patrol personnel because they were deputized as special assistant U.S. attorneys to deal with the volume. And that was something new to me, these SAUSAs, who were both in the agency that was apprehending people and prosecuting them. And so the consequence delivery system clearly had an enormous impact. And the Inspector General looked at exactly what basis there was for Border Patrol to conclude that prosecutions were effective in deterring migration. Because the April memo that I described, Attorney General Sessions, underscores that the purpose of all this is to deter future migration, future attempts by these individuals. And so the Inspector General concluded that Border Patrol is not fully and accurately measuring Streamline's effect on deterring aliens from entering and re-entering the country illegally. And so in conjunction with the 10-year anniversary of Streamline, which also took place in 2015, non-governmental organizations had concluded that about 750,000 prosecutions had taken place in that decade. The incarceration costs were at $7 billion. And there wasn't really an underpinning to know that this was a good use of the resources in comparison to other forms of deterrence. And the Migration Policy Institute, which is a very respected immigration think tank, got some data from DHS, not only showing that they were not analyzing this recidivism in a proper way, but showing that they couldn't, based on the fields that they had, make an accurate comparison between prosecution and civil immigration proceedings. So that would be the question, why can't we put people through the regular immigration court process rather than prosecuting them in these numbers? And it turned out that DHS was issuing what's called notice to appear, which is the initiation of an immigration proceeding, and then not being able to track in its data systems what happened to the person, whether he or she got relief, whether he or she absconded, whether he or she went through the proceedings and was deported, and then you could measure the recidivism. So essentially, you didn't have the numerator-denominator that you needed to compare the criminal prosecutions and the civil immigration proceedings. And so this raises a lot of questions in terms of the underpinnings of this mass prosecution effort. The other thing the Inspector General pointed out was that Border Patrol does not have guidance on using Streamline for aliens who express fear of persecution or return to their home countries, and its use of Streamline with such aliens is inconsistent and may violate U.S. treaty obligations. And I think the judges will have very interesting perspective on this, but of course the federal criminal system is not set up to deal with someone who says in one of their courtrooms, for instance, I have a fear of going back. You know, don't prosecute me for this entry or re-entry. I'm scared of going back to my country. That creates a whole different process with U.S. Citizenship and Immigration Services or DHS and ICE in particular, which may be having a detainer on the individual for after the criminal case. But there's no process in criminal court to stop things and say, let's assess whether you came here because of a fear rather than trying to break the criminal law. And so I think those critiques had a big effect in the late Obama administration on how this was perceived. There was also a model, because this wasn't being done, as I mentioned, across the border. In 2005, started in Del Rio, Texas. Each different Border Patrol sector, but also each U.S. Attorney's Office, had a different approach based in part on capacity, but in part on priorities, and in part on philosophy. And so in San Diego, in the Southern District of California, you weren't getting prosecutions of people without aggravating circumstances. You were getting illegal re-entry cases of people who had significant criminal records and were getting significant sentences. But you were certainly not having a zero tolerance or even anything approaching that. In McAllen, when I went, I was interested in the 36 people who were at the hearing. One of them at the end, because there was some allocution and discussion of personal circumstances before the sentences were all handed out, one person at the end didn't have a criminal record. And And I happened to be riding down in the elevator with the assistant U.S. attorney, and I asked him, what was up with that last person? It just didn't seem to add up. And he said, oh, well, of course, it's a crime to come in, regardless of your record. But it was clear that that person was there because there was a slot. And when we later toured the Border Patrol sector, they had red or green folders. And if you got a red folder, you were going to prosecution. If you got a green folder, you weren't. And there was a fascinating interaction because we asked them, there were flow charts that we were studying with interest in the Border Patrol station, and we said, why do you do this so fast? I mean, how can you figure out in 48 hours whether someone has a fear of going back? What's going on here? And they said, oh, I think we have to get the people there within 48 hours because it's a due process requirement. And of course, that didn't quite add up, and this may have been the first time the ACLU was not on the side of quick and thorough process, but of course they could be held in immigration detention and the prosecution decision could be made later. There was no pressure on the Border Patrol other than to fill these slots, to move people through at this speed. And this intimidation, I mean, how many people are comfortable having been apprehended, being in a Border Patrol station, telling their story, which may include horrible abuse on the way to the country, et cetera? And so I think the San Diego model is something to keep in mind. There is a lot of attention in Southern California to whether that U.S. attorneys' new policies will change, whether this intent to get away from the aggravating factors, especially based on today's memo, will have a big effect. And I think in moving to the Sessions memo, I would just like to elevate one question: who is prosecuted? I'm giving you a sense of the scale of these prosecutions, but the other thing to look at is really the qualitative side of this. And I think the University of Arizona and some others have looked at deterrence based on people who want to reunite with their families. We know the impetus to come here for work is strong. Imagine how much exponentially stronger it is if you're coming to reunite with your family. And so what the Arizona study did was try to ask and determine whether these sanctions really matter in terms of reuniting with your family. And their conclusion was no, that this is a part of the criminal justice system that is misaligning in terms of the incentives and the deterrence for people who have deep ties to the United States. And I think a statistic that is interesting, especially given my distinguished co-panelists, the judge who in 2015 was sentencing the most people in the entire country was in southern New Mexico in Las Cruces, Judge Robert Brack, and he decided to speak out. He said, I, over the last 5 years, have sentenced 6,708 people, and that was about 2,000 more at that time than any other district judge. And he said, it tears at my heart. And he revealed that he had written private letters to President Obama. He had been appointed by George W. Bush, talking about some of the people that he sentences and how he thought this was not why he had either become a district judge or how he believed the criminal law should work. And he gave the example of Luis Renteria Terrazas. Age 75, he was in the Bracero program, which was a guest worker program at World War II and after, and he was deported when the Bracero program ended, and we know that in the Eisenhower years there were some very aggressive and illegal deportations. And Judge Brack said he was punished and branded a felon for doing the very thing we invited him to do at a time when it suited our needs. And I think that was pretty powerful, coming from a district judge who's seen that level of cases. Judge Brack is not the only voice in the federal judiciary about these cases at the southwest border, but I think the decision to speak out like that was very meaningful at the time, and I encourage you to look at the Wall Street Journal interview with him. But what did Attorney General Sessions say in April 2017? He said in Nogales, in a very impassioned speech, that he would appoint a border security coordinator in every single U.S. attorney's office. So these prosecutions were happening elsewhere, as I say, in a continuity sense, in the Obama years as well. The sequestration, for instance, ended up with a judge in Nebraska in the federal district court saying, I'm going to deprioritize these cases. I don't really understand why they're in my courtroom, but if we're prioritizing, I'm not going to do them. We see cases in Pennsylvania. There was a good investigation by a newspaper, the Western District of Pennsylvania. So these were happening elsewhere. But imagine what it says to a U.S. Attorney's Office when this is coming from Main Justice saying you have to have a border security coordinator, and he specified which elements of the U.S. Code he expected increases in prosecutions. Transportation and harboring. We've talked about 1325, 1326. This is 1324. And we've seen this both threatened and actualized in terms of humanitarian aid in Arizona. Some would have read about a case where shelter or water was being provided. This is being prosecuted criminally. And the elasticity of these terms, transportation, harboring, is enormous and is really casting a pall over all sorts of immigrant aid networks, including legal advice, et cetera. And then he said, we should also focus on document fraud and aggravated ID theft whenever we can prove it up. And this is in the context of another memo that all of you are familiar with that disagreed with the smart non-crime philosophy of Eric Holder and said you want to charge the maximum available. And Attorney General Sessions emphasized that this offense, aggravated ID theft, has a 2-year mandatory minimum. So across the country, what we've been studying is how this has affected different districts in terms of numbers, but also qualitatively, what's being put in the criminal system that used to be in immigration court, how is it being used? And the other thing he said, and I'm interested if the judges have seen this, he really encouraged the entry in federal district court of judicial orders of removal. So this is something that federal judges can do, which is as part of the criminal proceeding, enter a removal order. And that would keep it out of immigration court because you got your deportation order as part of what the prosecutor sought in the federal criminal case. And so that memo is very significant, and today's will be as well, in reorienting the Department of Justice away from those 2 reforms that I mentioned in terms of the custody, of course, which is a matter of numbers, and also the type of private prison facilities, but also the prioritization. I mean, the memo today, it couldn't be more crystal clear that you're going to be accountable to Main Justice for these federal criminal immigration prosecutions.
Chris, if I can stop you there for a moment and just ask a question. And by the way, I should have done this caveat at the beginning. Yes, I'm from the World Bank. I'm here in my personal capacity, so my views are my personal views, not those of the bank. But I was wondering, I mean, when listening to what you were saying, I mean, we hear so much information, disinformation, contradictory information, fake news, real news in today's day and age. I take your point about how you are not going to deter someone effectively who wants to reunite with a family from crossing the border, probably no matter what the consequences are. But are illegal boarding or illegal border crossings, are they down under the Trump administration? If they're down, does that mean that the administration's hard line, as you've been referring to in the 2 session memos, is having an effect? If that's not the case, what is explaining the downward trend in these border crossings?
I'm really glad you asked that question because the numbers have to be looked at on a long view. And one of the interesting snapshots, because the other matter, and if anyone would like to discuss it more, I'm happy to in the questions, is the National Guard deployment this week, which is the equivalent militarily perhaps of this legal response. And the National Guard deployment has been touted as something President Obama did and President Bush did. And one comparison that one can make is in the month before there was a National Guard deployment, how many apprehensions were there in each of those 3 cases? And the March announcement from DHS this week was 37,000 apprehensions. In the month before President Obama deployed the National Guard, and I should say the ACLU opposed all 3 of these, but it was 55,000. And in the month before President Bush deployed the National Guard, near the end of his presidency, it was 126,000. And so if you look at that, the numbers are very different. But here's the key, I think, and the administration tells you this as well from a different perspective. It used to be that those apprehensions were almost overwhelmingly single males. Now, 40% of the apprehensions are family units or unaccompanied kids, many of whom turn themselves into Border Patrol agents. So their purpose in coming across is to find a Border Patrol agent to process them and put them in the system to address their fear of persecution if returned home. So the composition is very different. The other thing that's really different and important to keep in mind with these numbers is at the Bush deployment, there was half the number of Border Patrol agents at the southwest border. They were just in their hiring surge that led to other problems, but the National Guard could be seen as a bridge to getting plussed up to the number of Border Patrol agents that were in place by the end of the last decade. And if you take the number of people who are apprehended per month with the 16,000 Border Patrol agents who are now at the southwest border, and you even include those 40% that I mentioned that are families and unaccompanied kids, the average Border Patrol agent is apprehending little more than 2 people a month. And so there is no statistical link between overwork of the current level of Border Patrol and the number of crossings. Now, what the Trump administration is doing is comparing it to last March. And I think the implication of your question was that at the beginning of the Trump administration, in part because of misinformation, for instance, Border Patrol and the port officers were reported as telling people the U.S. is closed for asylum. You know, under Trump, it doesn't happen anymore. So there were definite efforts there. General Kelly made some very aggressive moves toward the Northern Triangle countries, in particular in Central America, to reduce. And so when you're comparing that over a long period of time, exceptionally low March of 2017 to March of 2018, you get this rhetoric of increase. But that's a relative increase, and you need to look at it in absolute fashion and exactly who it is. And I think it's a good segue to my last minute, which is just to talk about family separation. And there are a couple of cases that I'd like to cite which are interesting in this context. The first one is from El Paso, where in November, a magistrate judge was confronted with an unusual motion. There was a woman in front of him who, through her federal defender, said that the indictment under 1325, which is the illegal entry, was being used to make her plead guilty under duress because her child had been taken away. And she said that this was an illegitimate guilty plea because of the duress involved of making a choice between your child and this criminal prosecution being resolved quickly. And so the Houston Chronicle, in a couple of articles which I included in the materials, looked into how many of these cases. They went across the border. Hundreds of these cases were being reported in terms of a deterrent message trying to be sent. And this was Magistrate Judge Miguel Torres, and it's reported that he was very sympathetic in his remarks about this. He said, I can't imagine, the decision being forced upon a parent in terms of reuniting with the child versus the criminal process, but he denied the motion. He didn't think there were legal grounds, or he said a higher court would have to rule that this was something that led to the criminal charge being invalid. And so it went to the district judge afterward, and is now going up to the Fifth Circuit. The other case I wanted to mention is an interesting one from the Ninth Circuit in April of 2016, and it's called Argueta Rosales. And this was a man who said, I'm being charged with illegal entry when I was fleeing violence in Mexico and wanting to turn myself in to U.S. authorities. And the Ninth Circuit said, based on its precedent, that this was not a charge that could be sustained because the district judge had accepted this duress and yet convicted. And because in the Ninth Circuit, you have to be under official scrutiny, trying to evade detection to be convicted of illegal entry or reentry, they said that this was not within the purview of the judge to find both duress and to convict. And so I think that's interesting because you'll have the echo to what I was saying about the duress under which either a parent is pleading guilty in court, or why some people are coming to the United States and turning themselves in. What happens when someone says, I should not be charged under this zero tolerance policy because I was either seeking asylum, as the Inspector General found, or fleeing for my life with no intention of not being detected. So thank you for that.
All right, thank you very much for your remarks, Chris. I'm going to turn the microphone over now to the two judges, starting with Judge Porcelli to give a view from the bench. And I should have mentioned at the beginning, if you have questions, you don't have to wait till the end. Just jump on in anytime.
I'd like to start off by thanking everyone for the invitation to be here. I'm very excited to be part of this panel, and having got to speak with Chris earlier, I really enjoyed our conversation. Although I do have a newfound respect for you, realizing there's no way in the world I would sit on a panel with somebody I went to high school with, so I think that's impressive. But I do want to start off by asking this question to get an understanding where everyone is, and if anyone has actually handled one of these cases. And so Chris was talking essentially under Title 8, 1325, and 1326. But as a magistrate judge that sits in Tampa, I see individuals who do not have status come across in a variety of cases. The ones that I looked at for our caseload, the highest and most significant types of cases are the illegal entry and re-entry cases. We do have some good amount of document fraud cases, the drug cases, and there's a unique type of case I'll talk about in a moment where it's known as Operation Panama Express, where we're actually bringing in individuals who are interdicted in the Eastern Pacific Ocean and then bringing them right here to entry in Tampa. And then the occasional, at times, marriage fraud type cases. Each of them present unique questions on how they will be handled upon initial appearance, but more significantly as to the bond consideration. The bond consideration, more often than not, traditionally, may start off by the prosecutor indicating there is a detainer. And I will tell you, historically, that would normally end the discussion. And so I'm curious to start there. How many have participated in a bond hearing where there was a detainer filed against the defendant? All right, and then based upon the detainer, did the government just simply rest on the fact that the detainer existed and sought detention based upon that? Yes. And normally that would end the discussion. You know, the first thing is, if you've ever looked at a detainer, and I'd like to read it for you, the detainer itself states this detainer arises from DHS authorities and should not impact decisions about the alien's bail, rehabilitation, parole, release, diversion, custody classification, work, quarter assignments, or other matters. So the detainer itself speaks to it should not be considered for purposes of any type of consideration of bond. The second is there have been a number of courts, and providing the materials, there is a 10th Circuit case that I think speaks directly to this issue as to whether the fact that a detainer is in place under Title 18 United States Code Section 3142 is the possibility that if an individual is given a bond by the court and then removed to INS's custody or ISIS custody, and the possibility of deportation, is that the equivalent of flight or the risk to flee under F2 under the statute? The case law speaks directly to that point, and it's significant to address a number of things. The first is, if you consider the bond statute and how it applies, the first presumption is release. The next presumption is a release on certain conditions, and then the third is for detention. It's unique in the bond statute itself that under 3142 F1, where there is a request to detain based upon the assertion of danger to the community, the court cannot sua sponte move under that provision. The only time an individual can be detained as a danger to the community is if the government moves the court and requests that. Under F2, the court can sua sponte move for detention based upon risk of flight and the flee. So I leave you with that consideration to think in terms of you can have a defendant who has significant violent criminal history, is before you on a significant crime, and without the government moving for detention, the court cannot detain that individual. The issue of risk of flight and the concept of an individual who's before the court without any status is a difficult one. Primarily, more often than not, what is argued to the court is a number of these individuals are doing everything they can to stay in the United States, to come to the United States. So how are they, quote, a risk of flight? The calculus, in my view, on that is not so much a risk of flight to flee the country, but it is a concern about to avoid the prosecution. And if you follow the bond statute itself for the considerations of the court, the first consideration is the nature of the underlying offense. Then you consider the evidence, the strength of the government's case, which is the least factor, but nonetheless a factor for consideration. You are to consider the defendant's history and characteristics to include any criminal history. We were talking, which I was interested to hear the comment about the memo. I had no idea about that, but we were talking at lunch. So prior to taking the bench, I've been on the bench almost 9 years now. Prior to that, it was just over 9 years as a prosecutor. And I could not recall a prosecution under Title 8, 1325 for illegal entry here in the Middle District of Florida, at least in the Tampa division. In fact, historically, when I first started as a prosecutor, the only cases that were being prosecuted at the time were the aggravated felony offenses, the B2 offenses. Now we see more commonly those under B1 and also the occasional B2 charge as well. But even today, I cannot recall anything under 1325. Where I really discovered that is after I took the bench and got to know some of my colleagues who sit on the bench on the border states. If you're not familiar with how the United States Magistrate Judge position is utilized, we can be utilized under our statutory authority in any way the court sees fit. Here in the Middle District of Florida, the Magistrate Judge position is utilized to the fullest extent of the statutory authority. But on the border states, a lot of my colleagues, all they do is criminal. They don't do any habeas, they don't do civil, they don't do Social Security. All they do is criminal. And in fact, it's all misdemeanor criminal. It is the 1325 entry cases where they do them en masse. And so to give you a difference in perspective, when I have criminal duty, I would say a busy duty week for warrants, primarily I'm focusing on arrest warrants, would be if I got anywhere up to around 20 warrants. My colleagues can get up to, on the border states, the equivalent of 75 to over 100 over a weekend. And so obviously to address those numbers, they've addressed a number of procedures on how to handle that volume. And so the first thing is, and how they do the warrants is very foreign to me, but how they handle their warrants, it's all electronically, all put into a Dropbox, so that as they come in, the magistrate judge reviews them and executes them as they go through. The same thing with the initial appearances. They're done en masse, as well as at times the plea hearings are done with a significant amount of individuals going through the plea colloquy. Here, it's still my practice on any case, it's an individual colloquy with a defendant. The initial appearance is very different because each district can decide on how they want to do their pretrial service report. There are cost containment measures that pretrial services themselves has taken into consideration, and some offices will not even write a report on anyone who does not have status and has a detainer filed against them. The report will simply be a paragraph noting that, rather than the full report you see on most other criminal cases. That reason why that's significant to me is because the very issues that may come into play under the court's considerations for bond determination will not be available to the parties to even argue. The primary consideration, I think, is first and foremost the ties to the community you can establish from an individual. When you're dealing with individuals who come here and are being charged, for example, with just a 1326A, the court's going to look, is there a criminal history? And if not, then the next question is going to be focusing primarily on the risk of flight. And how do you argue the risk of flight, which is the thrust of that argument is simply that, to avoid the prosecution. And there are a number of ways you can present arguments to it. The first is the ties. If they're, as Chris was talking about, it's a mixed status family, those that do have status that are in the country, I think that's a significant consideration. The next is how long have they been in the community and what have they been doing in the community? The one that's probably most difficult for a lot of these defendants to address is, can they secure a bond in any way? Is there collateral that can be posted to help secure the bond. I raise these things because they are valid considerations. And what I think is, as I stated before, if you look at the bond statute, there are presumptions for certain crimes for detention. It is unique to me that these types of cases do not carry a presumption. If Congress intended for detention to occur every time in these cases, you would then expect that there was a statutory rebuttable presumption for it. For example, in a drug case, if there is a possibility of a mandatory or in excess of a 10-year term of imprisonment, there is the presumption the defendant be detained. There is no such presumption in these types of cases, but if you look statistically at the detentions that are occurring, it's overwhelming those that are being detained are those that lack status as compared to the other types of cases. To give you a point on that, this is based upon a 12-month period ending June 30th of 2017. The rate for release of individuals who lack status with a detainer filed against them nationally was 9%. Here, the 11th Circuit, the rate was at a 3% release. Where I sit in the Middle District of Florida, the rate is at a 1% release. Yes?
If I may ask, what do you mean by status? Do you mean that they're refugees, or is it those who have status?
Just no legal recognizable status as far as what the detainer filed against them.
So they're not refugees?
Not refugees.
Crossed, or they exceeded their
Exceeded their, yeah, exactly. So these numbers are staggering, as I just stated. If you look at the bond statute itself, they're low. They're exceptionally low. The one thing that I will say is, when I looked a little bit further into the numbers, especially here in the Middle District of Florida, I need to emphasize those are the cases with detainers on them. There have been a good amount of cases where individuals did not have the status I'm talking about, but did not have a detainer, or the detainer was originally filed and then withdrawn. So looking at it from the perspective of magistrate judge position, there are a number of issues that become very difficult. One of those that I think I struggle with the most is the mixed status family. When you have those individuals, it gives me a little more comfort in determining release, whether there are significant ties here that will ensure that they will. And we were talking about a case that happened in Orlando where essentially it's a mixed status family where someone was taken away from their family, is still in custody, and has been in custody for several months. And when I hear that, that is a case that I think that should be part of what we call our fast track program. And Judge Mendoza is going to touch upon that. But I did want to just quickly address that for a moment to say this. If you are representing an individual who is charged with one of these offenses, has a detainer filed against them, I think the quicker you can assess whether they can get into the fast track program, the better you do your client service. And the reason for that is, at least in the Middle District of Florida, by the time they enter a plea, they could go through the system within a good amount of 60 days and probably shorter than that. So the fast track program is very effective. The issue is, can you address it early on? If they're just languishing in jail, the more time they stay there, the longer then the sentence is likely going to be for them. So that's, at least from the perspective of a magistrate judge and how we see these cases come in. And my primary role that I see is in focusing on the core issue of release. And as I just outlined in the numbers, very seldom do they get released when they're brought on these types of charges.
All right, thank you for having me, and let me just present you with some anecdotal observations I have from the bench, because unfortunately, or maybe fortunately, when these cases arrive in my courtroom, I'm generally towards the very end of the process, so there's very little wiggle room for me. But let me give you two different circumstances that I've observed in the last 6 months. We have a gentleman who's in the country illegally. Unlawful reentry is the charge, and he's got a lengthy criminal history, and that includes domestic battery. The most recent incident, he was arrested for pretty badly beating up his spouse in front of the children after he was in an alcoholic haze. He's arrested, brought in. He's held in custody for 3 or 4 months before he finally makes it into my courtroom, and I have a decision to make with regard to what his outcome is going to be. On the other end of the spectrum, we have a mom who lives in Orlando with her husband and 2 children. The rest of the family is here legally. She has no criminal history except for the obvious, the entering unlawfully. She's on her way to work. She doesn't have a driver's license, so the husband, before he goes to work, takes the kids to school, drops her off at work, and then he goes to work. She's riding in the car with him, and they're pulled over. I'm never told why, although I try to find out why they were pulled over, what the basis for was. It was local law enforcement. No one seems to know. But what I do know is that she's taken into custody because she immediately admits that she's in the country illegally and that she's been removed previously. She's taken into custody. She's held for over 3 months, just like the other gentleman I just mentioned. And I have to sit in a courtroom. Of course, when he's sentenced, there's no one in the courtroom. There's a part of me that wonders if the family's relieved that they're going to get this tyrant out of the home. But when she's in the courtroom, she's accompanied by her husband, who's emotional, in tears, and 2 children who are crying their eyes out because mom, they haven't seen for 3.5 months, and she's about to probably be deported. And I tell you those 2 situations because it is alarming that they're treated exactly the same. There's no difference with how they're treated. There are very few details available to me. I know the first gentleman was taken into custody because of a domestic battery situation, but I don't really know the facts surrounding why they were pulled over, why she was asked questions, why she was taken into custody, and why she's been waiting for a hearing for 3 months. It is a difficult situation to try to manage. And I will tell you that all of the power, all of the decision-making, all of the authority is in the hands of the Assistant United States Attorney. So when you hear words like zero tolerance, it makes you, as a federal judge, think back to the days where we couldn't exceed or go below the guidelines. We had no authority. Whatever the guidelines said, that's what we had to do. And of course, there was some jurisprudence to determine that that was not lawful. This is troubling to hear those words because these prosecutions are going to increase, and all the authority is in the hands of those who are making this decision to apply a zero tolerance policy. So for example, what to charge, who to charge, how quickly to charge, it's all in the hands of the government. So, yes.
But you are appointed for life, correct?
Correct.
Yeah, so you have the ability to not abide by Sessions' direction.
Well, I don't plan on it, but in terms of when a lawfully filed criminal indictment or information is filed, and someone appears in front of me after being in confinement for 3.5 months and there's a guideline range, sure. What I can do is offer some friendly criticism and sentence them to time served, but
Can't you make inquiry? Like, what caused you to be here? Was it an illegal stop? I mean, you have the ability to do that from the bench, correct?
absolutely. And I encourage that, and when I do my own changes of plea, I inquire as to what those circumstances are. So certainly that's an avenue of approach.
So doesn't that train your U.S. attorneys then? That
Well,
not
but-
bring those type of cases to you?
But you have to measure that with a defendant who very much wants a fast-track type of resolution so they can get out as soon as possible. So if I gum up the works hypothetically and say, I don't think there's a factual basis for this plea, I don't think it was knowing and voluntary, or then what happens next? We set it for trial. And then we're gonna have a couple months removed. Any opportunity to get a time-served sentence and have the government charged with a very low ceiling is off the table at that point. So the question is, the decision up front to have someone taken into custody, held with no bond, and what to charge. And that's in their hands. So from a practical perspective, what I would encourage you to do, for those of you that are not CJA attorneys, I think it's a very valuable thing to have in your tool belt. That's a Criminal Justice Act attorney.
What's in my tool belt?
No, your ability to communicate quickly with the prosecutor to try to, I mean, this is really a damage control situation. Because if they make the decision they're gonna pursue this, and it sounds like it's gonna get more aggressive now, based on what we heard over the lunch break, then damage control is really something that you can use to try to limit their exposure. So some of the things you can do, there are 3 different types of ceilings that you have with these illegal reentry cases. There's a 2-year maximum, a 10-year maximum, and a 20-year maximum. The 2-year maximum is for those without a prior felony criminal history. The 10-year maximum is for those that have a felony history, and the 20-year maximum is for those that have an aggravated felony history. The one tool in your belt that you can use is the fast track program. If you can get to the prosecutor quickly, you can have some impact on how it's going to be charged, what type of exposure they're looking at, and how quickly you can move them through the process. And it feels a lot of times like you're making lemonade out of lemons, that's not really the ideal circumstance, but you play with, yes?
Well, on the fast track program, I know that when I was on the trial court, lawyers from other jurisdictions where the fast tracking was not available would come in and make that argument on an equal protection ground sometime. And I wonder whether the fast track program has been expanded, or is it still only limited to those defined communities, those border communities primarily?
Well, we're not a border community, but it is used, and it's used pretty aggressively in the Middle District of Florida in the Orlando division. And from Judge Porcelli's reaction, I think that they do it in Tampa as well. But there are some conditions there. I mean, there has to be a limited felony criminal history. There has to be a plea within 30 days of arraignment, and there are exceptions to that depending on how the circumstances unfold. No aggravated felonies, et cetera. And it is a tool that they often use to try to give me, and you know what's particularly troubling? I do what I can, and what I tell all my federal defenders and the prosecutors are, after the change of plea, whenever, because they do a shortened version of a pre-sentence investigation report to move the process through, I will tell them, as soon as anything is ready in terms of a report, call my deputy clerk of court, and if we have to do it during lunch, in the middle of a trial, or at the end of a day, we'll do it to move them through the process. That's pretty much what we can do. We're limited to that effect. This is really an area, and you know, I'm not saying this as a criticism, it's just a fact. The executive branch has all of the discretion here. They make all the decisions, and we're put in a situation where we have to react. And I oftentimes have prosecutors come in, and how valuable is a recommendation from a prosecutor when for the 30th time in a row they told you, we're recommending a guideline sentence? What does that mean? It means nothing. But when you're looking at someone who's told unequivocally that is what the recommendation shall be, or else, then there's nothing you can do, and you're in a situation where prosecutors are doing what they're told, the cases are being filed exactly how it's being ordered from the top down, and you're in a situation where it's a time-served type situation. I have a lot of solutions that I have that I think could address these issues. I just don't think I'm allowed to talk about them. Having said that, it is the most difficult part of my practice. Mixed status families are heartbreaking. There are things that can be done that I just can't do. And I wish there was something we could do to try to avoid those situations, but I've racked my brain for some time. It is an emotional situation. You feel like you leave a piece of you behind you every time you see a family that's about to be ripped apart. Florida's not exactly an easy place to migrate back to if you're removed, because we're not a border state. So what I would implore you to do is, if you're not involved in representing people who don't have status that are being prosecuted in that regard, you can do damage control, and that's a very important process to these families, because I don't know what their futures are. To answer the question, are we going to engage in removal orders per the request of the Attorney General? In the situation involving the mixed status family, I don't know of anyone who would do that. I think they're entitled to their due process, not just the conclusion at the end of a sentencing hearing. With regard to the gentleman who's a habitual domestic batterer, I don't know what the answer to that is. I wouldn't do it sua sponte, and I certainly have never been moved to do that by any counsel appearing in front of me. But I just want to give you an idea of how difficult these circumstances are. And I don't know that there's any solutions from my end other than trying to mitigate their exposure. I routinely have people that are fast-tracked or held in confinement that appear at sentencing, and they get, for example, a 0 to 6 guideline range, and they've been waiting for 3.5 months to get sentenced because of how problematic our processes are, how there's no such thing as withhold of adjudication in the federal system, how I'm required to wait on a pre-sentence investigation report before I can sentence someone, even though that's causing more harm than good. Those are a lot of the hurdles that we sort of have to absorb and just move forward in the process. So if you get involved in these cases, it's incumbent upon you to reach out to the prosecutor as early and as often as possible, because right now, the way the circumstances exist, the best you're going to be able to do for your client is damage control. And for those of you who believe that it is offensive for someone to stay 1 day longer in confinement than absolutely necessary, these cases are a textbook example of that, of a perverted way that we handle these cases. And I will tell you, sometimes these defendants are just afraid. They don't know what to do. They want out of jail. They feel bad because they've been arrested and they know they're here illegally. In a lot of the cases, they'll just volunteer the fact that they're here illegally after having been removed from the United States. And it's troubling how they're treated and how they're processed through the system. And again, I guess my biggest problem with what I see is we paint with a very broad brush. Some people who deserve absolutely no mercy from the court are treated differently than someone who's just trying to find a better life for their family. And it's the one thing that I think when I become a senior judge, I won't hear any more of these cases because I think they're really difficult to manage. And do we have any AUSAs in here? All right, if I could encourage you.
I don't do those cases, Your Honor.
All right, so if I could encourage you to reach out to your colleagues, there are a lot of ways these cases can be handled, and some of the things I see are really troubling, and I don't think they're what was intended in this process that we all work in. So if you're not a CJA attorney, that's a first step in the right direction. Some of these very novel, I can't do this sua sponte. Some of these very novel motions that we've heard mentioned today, they don't get filed. They don't get filed because these are assembly line cases where people have them plead as quickly as possible to get the lowest amount of exposure and get them out the door. I would really love to see how this thing would evolve if we had persons in the courtroom arguing these motions. And by the way, I do have people, after they've entered a plea that's been accepted by a judge, I've had them tell me, I fear for my life if I return to my country. And if I set up an evidentiary hearing, there's really nothing that's presented to me to give me enough to hang my hat on. So those are the types of issues that if you can get to them early, if you can talk to them, if you can make them understand that their fear is unwarranted in this process that we all work in, that maybe there's a chance to make some change. But that's going to start with very capable attorneys such as yourselves coming in and making those novel motions in front of judges who feel like their hands are tied.
I didn't mean to suggest, forgive me for interrupting you, but
No.
I didn't mean to suggest that I wouldn't take your comments back to my colleagues. So
No, I appreciate that.
I'm very close to, the powers that be in my office, so I certainly am interested in your comments. I just wanted you to know that I'm not one of those prosecutors.
No, and I understand. I mean, there's a practical component to this. These are prosecutors that like their jobs and want to keep them. But I would say that I'll just finish with this. The zero tolerance I just heard about is heartbreaking, and it's a step into the darkness. Thank you.
I want to follow something.
Yeah, sure.